Now, this webinar is being recorded and we will post that recording to our PD Active YouTube channel in the next few days. In fact, Monique, if you've got a second, if you can put that URL in the chat window now, people can grab that and copy and paste it somewhere else if you like. But when we send a follow-up email after the fact, tomorrow or the next day, we'll also have some of these important links in that. Finally, PD Active depends on donations to bring programs like this to our members free of charge. And we certainly remain grateful to for your contributions. If you have not yet had a chance to make the suggested registration donation of $10 for this roundtable, we will paste that link into the chat feature now as well. There's also a big green donate button on the upper right-hand corner of the PD Active homepage, which you can find anytime you like. Throughout our presentation this evening, we will present you with a handful of poll questions, which will pop up on your Zoom screens. Please answer these as quickly as you can so our speakers may respond to these in the flow of their presentations. If you prefer to not answer the questions, merely close the windows when they pop up. We will start with one right now to give you an idea of how they work and to give our presenters an idea of how they look. So there's the first one, and you can answer those and move that window around by grabbing the top of the window and pulling it off to the side if you like. If for any reason any of the four of us gets disconnected from this Zoom meeting, which I highly doubt, please be patient and do not disconnect or leave the meeting for a few minutes as we try to get reconnected. It is possible that Monique may take over as host if I'm disconnected. And now, without further delay, PD Active is pleased to introduce to you our panelists for today's roundtable, Dan Feinberg and Travis Neal. Dan is a partner in the law firm of Feinberg, Jackson, Worthman Wasow LLP, and he has over 30 years of experience in employment litigation. Read more about Dan at his site, which we'll post into the Zoom chat window now also. And Travis is a trusts and estates attorney at Hartog, Baer Hand, APC, himself with over 15 years of experience in estate planning and administration matters. And you can read more about Travis at his site, which we'll also lob into the chat window. So welcome to you both. I'm sorry for the long-winded intro, but thank you for joining us today. Let's see, Dan, why don't we start with you? And I've got most of the attendees on mute, but let me start before you dive in. Let me start by ending this poll and share the results. The polls I will leave up for all of about 30 or 60 seconds, everyone, just so you know. But it looks like we've got 65% of the folks attending with us today who have been diagnosed with PD, myself included. Six of the folks in attendance, or 18%, are PD caregivers or care partners. A few work in the community, and a few are concerned family members, and a few others. So give me 1 second, Dan. Let me grab your presentation and share screens in a second here, and we'll get started.
Thank you. While you're doing that, I'll just say that my law firm is located in Berkeley. Contact information is in the URL and also on the first page of the presentation. And feel free to contact me after this if you've got any questions about disability benefits. Always glad to help folks out, and hopefully this will be informative. So I'm going to go through the PowerPoint quickly. I'm not going to talk about all the details in the PowerPoint. You can look at it after the presentation if you want more details. So the first point is, like, how is it that you prove disability? And that's actually an interesting question because, normally you would say to yourself, well, I just asked my doctor to support my disability claim. But the thing is that establishing your right to benefits under a disability insurance policy or some other disability program actually requires a combination of both medical evidence and vocational evidence. And so that's where things can get complicated. And what you need to show also varies greatly depending upon the specific contractual definition of disability. And so those are sort of the high level points about proving disability. Now, for Parkinson's disease, there's certain medical issues that give rise to disability claims for most of the individuals claiming disability. And Todd, I've moved on to the next page there. Thank you. So, I don't need to go over the most common symptoms with you folks, but all of the bullet points here are issues that are well-known PD symptoms that can interfere with your ability to do your work or really function at a high level in doing the activities of daily living. So, when it comes time to file a disability claim, if you've been working and your disease progresses, you need to think about which of these issues are really, limiting your ability to perform your job. And then you move on to the next page in the presentation, and you have to think about what evidence do I have to support the claim. The first thing that comes to mind is your doctor's records. Whether you belong to Kaiser or any other medical system, your providers have chart notes, test results, et cetera, prescription records that are obviously, the starting point for a disability claim, because that's the first thing an insurance company is going to want to look at. But then there's other evidence that you'll need to provide or gather. First of all, every insurance company will require you to submit a bunch of disability forms, more than you would really hope for. But the attending physician statement is key. You need to have a treating physician who is willing and able to spend a little time on these forms and support your claim. And getting a doctor's cooperation can be difficult at times. And it's crazy when I have to tell my clients that, when you're looking for a good doctor, you're not just looking for a skilled medical practitioner, you're also looking for somebody who realizes that their job doesn't end, at the door of the examining room, because they have to help you with other aspects of your life, including disability forms. And of course, your employer will need to provide a job description or other information about the job requirements. And sometimes that can include performance reviews. And then, a lot of it also is information that comes from you, because nobody can tell the story better than you can or your family can. There will be forms that you fill out where you provide a personal statement, your symptoms, your limitations. We often encourage people to keep a journal of their symptoms. And there's now these online programs that help people to do that. And getting, sometimes it helps to get supporting statements from friends, family, coworkers, et cetera, where you can give the insurance company a better picture of the before and the after. And then to the extent that you are filing for government benefit programs, there's certainly going to be additional records from those, things like Social Security, disability insurance. And then last on this list, the insurance company will often send you out for a so-called independent medical examination. It's obviously somebody hired by the insurance company, so their independence is, shall we say, somewhat in doubt. But they have the right to have you examined. All right, so then, the first question in terms of what you use this evidence for really depends upon what coverage you have. There are short-term disability programs. Everybody I think everybody here lives on this Zoom lives in California. California is one of the states that has mandatory short-term disability insurance. Most people have it through the state program, which is run by EDD, Cal SDI. Most of us pay taxes for that coverage. Companies can opt out and provide their own short-term disability coverage. But then the bigger question is, do you have long-term disability coverage? Because the short-term benefits usually only go for 52 weeks. And then, so the question is, do you have long-term disability coverage? Depending on the policy, that can go either to age 65, or sometimes they go later. Some of them are even life-term policies. And then the big issue there is, what form of long-term disability coverage do you have? If you work for a private employer or any big private employer, many of them offer group long-term disability coverage. If you work for a public employer, they often also provide group long-term disability coverage. But some people, especially professionals, have gone out and bought individual disability coverage. And I see that a lot of people here are still employed, either part-time or full-time. And, only sort of a minority of folks have sort of self-employment. Majority of folks have disability insurance coverage, which is good. So,
and Dan, I'll pop up the next one, which talks a little bit more about which types of claims here too.
Sure. Individual policies you most often see professionals buying that, and that's done on an individual basis. It's not provided by the employer. And I should say I'm being a little bit simplistic here, because believe it or not, you wouldn't be surprised, there can be some gray areas between what counts as a group policy and what counts as an individual policy. And then the one thing that almost everybody has, 99% of people have, is Social Security disability coverage, which is a long-term program. Essentially, you start your Social Security retirement benefits early, and that goes to age 65. So, once you figure out what coverage is available, that that is a key consideration for figuring out what legal regime you're operating under, because this is where things get confusing. Group policies are generally covered by a federal law called ERISA, the Employee Retirement Income Security Act, which most people think of in terms of pension plans, but it covers other kinds of employee benefits sponsored programs sponsored by private employers. Government employer programs are not covered by ERISA. And then you have individual policies, which are going to be subject to state law. For you folks, almost all of you, it's going to be California state law, which is a good thing. It seems like a number of people here have open disability claims, but the vast majority of folks haven't filed a disability claim yet. And so, Social Security disability is a separate program that has its own rules under federal law. It only kicks in after you've been out of work for a year, and it has some important features that the other programs don't have, because, for example, you qualify for a Medicare coverage if you qualify for Social Security disability insurance benefits, and that can be very helpful to folks with chronic illness. So, essentially, the group policy sponsored by private employers are covered by ERISA. That brings with it certain procedures and limitations on remedies. The individual policies are going to be governed by the California Insurance Code. That has a very different procedure for enforcing your rights, and it provides a broader array of damages in the case you have to battle with your insurance company and file suit, which hopefully it doesn't come to for you folks. All right, let's go a little deeper into this. The next page here.
Yeah, and Dan, if I can just elaborate for a second for folks, the group policy means a policy that you'll probably have through work, right? A larger insurer.
Yeah, a group policy is always going to be through work. or
And then-
or 99% of the time. There's a few exceptions.
And then an individual policy is something you might get privately, personally through a carrier on your own.
Right. Sometimes, like if you are a partner in a medical practice or a law firm, let's say, you can be buying, or an accounting firm, those folks, the partners may be buying individual policies through the firm, and that's covered by California insurance law.
Mhm.
But to keep things simple, if your employer is providing the coverage, it's typically going to be a group policy.
Right. Just wanted to clarify that for folks.
All right. So short-term disability here, I talked about this briefly. There's Cal SDI for folks. That's limited to 52 weeks. $1,540 per week is the current ceiling on those benefits. It's administered by the EDD. Most people don't have, if you are disabled, I don't find many people having problems accessing the Cal SDI benefits. Sometimes you will see employers also providing a short-term salary continuation benefit or short-term disability income coverage. And those are different. Occasionally, a private employer can have a program that takes the place of Cal SDI. So this is not where people generally have problems. It's only when you get to the next slide and you're talking about long-term disability coverage that people have problems. So group long-term disability, once again, this is if you work for an employer and the employer goes out and buys a group insurance, disability insurance benefit, or sometimes sponsors its own group disability program. This is frankly the most common kind of coverage, especially through private employers. And typically it provides benefits up to age 65. You get a percentage of your pre-disability earnings, usually ranging between 50 and 1/2 and 2/3. And there's always offsets from the disability benefit. You're required to apply for Cal SDI. You're required to apply for Social Security disability insurance. And if you get those benefits, those are offset from the LTD benefits, less money being paid from the insurance company, which is, of course, their goal. And typically, this is provided through an insurance company. There's a few big ones out there, like Unum is the biggest. Prudential. There's several other major insurance companies that are big in the LTD benefits field. Sometimes a big employer will self-fund the plan, and that's less common. All right, going on to the next page, just to let you know, this is like identifying the different species of animals out there in the field. Private individual disability insurance is one that you buy yourself. If you're a partner in a professional firm, sometimes you're paying for it yourself, but the money flows through your K at the K1 level. So that's still an individual policy. And key differences here is for individual disability policy, usually there's no offsets. Usually it's not a percentage of your pre-disability earnings. You're going to get a set monthly benefit, $5,000 a month, $10,000 a month, et cetera. Almost always these are occupation specific. It's can you perform your occupation? I didn't mention it in the last slide, but group disability most often is based on your own occupation only for 24 months. And then it becomes own any occupation, which is the standard for Social Security disability insurance benefits. Can you perform any job for which you are reasonably qualified by reason of age, education, experience, et cetera. They can't say to somebody who was a rocket scientist, you should be working as a barista, but it doesn't have to. The measure of disability isn't necessarily doing your specific occupation. They'll often say, "Oh, you should do outside sale. You should do sales from home, those kinds of jobs." Anyways, as I talked a little bit about this also being subject to a different legal regime, which we'll go into a little bit more later. And then the last, where was that? And the next slide, I talk a little bit about Social Security disability, which is, as I said, the any occupation standard of disability. It's administered by Social Security Administration. It's a very bureaucratic process. There's different forms that you fill out, and it is also like Cal SDI, there's a maximum benefit, and the amount of your benefit is based upon how much money you've been paid into the Social Security system, so that people who are high wage earners, up to a certain point, get a higher benefit. And but it has a high floor and a low ceiling, so there's not that much variation in the benefits. One thing that's not on this slide is if you still have dependent children, they get an additional benefit. It doesn't matter how many kids you have, the dependent benefit is half of your benefit, and it stops essentially when they graduate high school, and at that point. And this is really just like early payment of your Social Security retirement benefit, with the added benefit of qualifying for Medicare after you've been disabled for a period of time. Moving on to the next slide.
And Dan, you made the point earlier about offsets. So just to remind folks that if your LTD for group is coming in at X $1,000, and then they force you to sign up for Social Security disability, and that comes in at Y $1,000, the group will withhold that Y amount from your monthly payments.
Indeed, yes, yeah. I mean, just for easy math, if your group disability benefit is $5,000 a month, and your Social Security benefit is $2,000 a month, you're required to apply for SSDI, and once you get it, the group disability benefit will drop down to $3,000 a month.
Yeah.
And that's, but of course, if you're denied Social Security disability benefit, you might still be eligible for the benefit under your group plan, and they have to continue paying the full $5,000.
Right.
What did you mean in the slide where it says freezes retirement benefit?
Oh, yes. So once you're on SSDI, you're no longer paying into the Social Security system. Your retirement benefit's not going to go up. Every year, for those of us who are working, you're paying into Social Security system every year, and your Social Security retirement benefits going up. So, but once you apply for SSDI, that benefit's frozen, and you're not going to see anything higher once you turn 65. Unless, of course, you recover and go back to work. But, assuming that you're out on SSDI and you remain out on Social Security disability until you reach age 65, retirement age, for some of us, it's a little bit higher than that now. You're going to, you're not going to see any increase in your Social Security benefit once you hit retirement age. That's just talking about the base amount. I'm not talking about the cost of living adjustments that everybody gets every year based on inflation, which suddenly has become a bigger number.
Okay, moving on.
So for those of us who have group LTD coverage through a private employer, here's the key things about the procedures required for those claims. You have to go through an administrative claims process on these claims. Like, you submit the initial claim, the insurance company has a period of time where they have to give you a written decision. If they deny your claim, you don't go to court right away. You have to prepare an administrative appeal that goes to the same insurance company. It's a little bit strange because the entity that's deciding the appeal is the same entity that decided the claim usually. And you have certain rights, like you can get a copy of the claim file free of charge, which is really important to see what the insurance company is thinking. And perhaps you'll find some evidence of some improper conduct or stupidity. Only after the appeal has been denied, do you file a lawsuit. And the lawsuit has to be filed in federal court, and there's no right to a jury trial. It gets decided by a federal judge. And typically, you're going to have the case decided on the paper record. In other words, the judge is just going to review what was presented as part of the administrative appeal. That's a slight oversimplification. And so it's really important that your administrative appeal contains all of the evidence supporting your claim. I mean, this is something that I do a lot. People who have to go through this process would be well served to hire an attorney who is experienced in this area, because it's really not a good place to make a mistake or be an amateur or do it yourself, because only somebody who's really experienced in this area knows what kind of evidence will sway the insurance company or will be convincing to a federal judge. And also, knows how to be exhaustive about submitting evidence, because this is kind of your last chance to do so. Moving on to the next slide. So the individual coverage is as we summarized before, is very different. This sort of hits the key points. You get to a few things that aren't here is under an individual policy. You're filing in state court initially. It may get removed to federal court. You may end in federal court under diversity jurisdiction, but you have a right to a jury trial. There's no limitation on the evidence. You can put in new evidence during the case. You'll have a trial where witnesses testify. It's not a paper record. And, some people think that the insurance companies tend to be scared of individual bad faith cases in California courts. For one thing, California is one of the states that permits a wide range of remedies for insurance company bad faith, including possible punitive damages. So those of us who have been doing this for a long time have a firm belief that the insurance companies, shall we say, handle California individual disability claims differently than they handle group policy claims, because they're more worried about remedies under California law and facing a jury. Let's move on.
Hey, Dan, may I throw in one more little anecdote here? I can also contribute the fact that the first bullet under ERISA plans is benefit based on set percentage of salary plus bonus. I was pleased to find out.
Well, so that is, yes, that's generally true, but the definition of covered compensation varies a lot from policy to policy. So that's not a standard provision. And there's some people who get paid on commission or get a lot of bonuses who actually are very unhappy when they file their disability benefits.
It's just base.
Yeah, I mean, you were fortunate, but I represented somebody a couple of years ago who was in the investment, who was in finance, and the plans, the company had bought a really poorly designed disability insurance policy for somebody who's involved in finance, because it only covered base salary, and anybody in finance makes at least half their money on bonus.
Yeah, so that would be something for our listeners to check in on the specifics of their policy.
Yeah. There's generalizations are hard to make because you really do need to look at your policy.
Okay, thank you.
Right, and then, so yes, well, that was a good segue because important considerations is specific policy terms. You really need to look at the definition of disability in your policy. You need to look at what compensation is covered for purposes of the benefits percentage. And, there can also be limitations on mental and nervous disorders and certain other conditions. Most of those should not apply to somebody with Parkinson's disease. And of course, the definition of disability often changes after 24 months. And so what may be of concern to some of you folks is, a situation where the insurance company says, well, okay, you can't do your specific job because it was very physically demanding. Like, you had to travel all the time or work 80 hours a week or lift heavy objects. But now that the policy shifts to the any occupation definition of disability after 24 months, we think you could, work as a file clerk or do some kind of, administrative or desk job. And then traps to watch out for are ones that are on the next couple of slides. Actually, I think I've covered some of them, but
and if those are things that we can, we'll be, again, for everybody's information, we'll be posting these whole entire decks on the website. So if we need to fast forward a little bit here to get the Travis.
Right. Yeah. So once again, you got to know your policy terms. That's the next slide. You can get a copy of the policy from the insurance company. If you don't have it, they'll give you a replacement. I've talked about the difference between own occupation and any occupation. That's another slide coming up. And then the key exclusions I've talked about. I've talked about a couple of them, but let me just hit upon a couple others. Sometimes you see a limitation on so-called self-reported symptoms. They insist upon having essentially like a dipstick test. Like they want to know that there is some kind of medical test that confirms your diagnosis or your symptoms. And then there's objective evidence requirements. A lot of these issues aren't likely to apply to somebody with PD. You may see some attempts to kind of shoehorn you into a mental and nervous disorder limitation, but I'm going to skip over that because I just don't think that is, I just don't think that most of these problems come up so much in PD claims. So at least I've represented a lot of people with PD on insurance, long-term disability insurance claims, and those haven't been an issue. Let's skip to the 20 because I know we need to move through this very quickly. And one thing that you see there you go, is the insurance company will often want you to go to a doctor they hire. You have to be very careful about this. If you're, I, as a lawyer, I scope people out and I make sure that the people are properly qualified. I make sure that there's no flaming red flag about them. I once had a client who's they wanted to send out for an independent medical exam, and the doctor was actually subject of a Medicare fraud investigation at the time that got a lot of publicity and was later indicted, or maybe had just been indicted. So you'd be surprised at some of the people who pop up to do these exams, but you always want to make a record. It's important to bring a friend or family member to observe, take contemporaneous notes, like right after the examination, make notes of anything strange that happened. Insurance companies love to do surveillance on people. So if there's a guy in the waiting room wearing a trench coat, you know why he's there. Make sure your key medical records are available and are reviewed by the the independent medical insurance examination doctor. And, you can ask for a copy of the report. And that's, you have a right to get that typically. Sometimes they'll push back, but usually you'll get that. And then the last thing you need to do is warn your doctor, treating doctor, to expect a call from the insurance company doctor. We call it the doc to doc call, where they try to ask your doctor leading questions and essentially concede that you're able to work or somehow discredit your symptoms. Sometimes they always follow that up with a letter to your doctor confirming what your doctor supposedly said. And this is kind of a problem because your doctor is busy and doesn't really have time to play these games, and sometimes doesn't really pay attention to these kinds of tricks. So that can be a problem.
Mhm.
And then just really to go quickly, I'm going to skip to number 8, which is number 22. You really need to get help with a denied claim. You can get a copy of the claim record, the file record, and you can get but you need to do a very thorough job on the appeal. And I think I'll just skip to the last slide now, number 24, number 9, which is, once again, to emphasize the importance of having a lawyer who knows what they're doing prepare the appeal, because that's the record you would be stuck with in court. And sometimes I find insurance companies encourage people to do the appeal on their own and, kind of encourage them to do it quickly. The claims rep who's giving you this advice is not your friend. Let's put it that way. And so at that, I'll end for this evening. Folks can go back over the slideshow or contact me for more info, and I'm happy to take any questions that have come up.
Great. I'm going to load up the title page while we're having Q&A so that folks can see your contact info.
Thank you, Dan. That was wonderful. It was very
Really
informative.
Oh, thank you.
That's such a full topic. It's just hard to cheat it with just such a short timeline, but we do want to get you some questions and then we'll move over to Travis's. Go ahead, Monique.
Yeah, we had a question come in on the chat. Once you're diagnosed with Parkinson's, is there any opportunity to update your policy or to get a new policy?
Yeah, so if you have individual disability coverage, that's medically underwritten. So, I'm not an insurance company, but and I don't work for one. I think that once you've been diagnosed with Parkinson's disease, to the extent that medical underwriting is required for an individual policy, I don't think the insurance companies are going to write you a policy. Some policies, if you already have existing coverage, the policies sometimes give you a right to increase your benefit level without further underwriting. And so if you're fortunate enough to have one of those policies, obviously take advantage of it and increase your benefit level. And finally, if you're still working and you're working for an employer that sponsors a group disability plan, group disability programs don't have individual underwriting. So like if you change jobs and well, actually, if your employer, adopts a better plan, you'll be covered. Sometimes there's a window period where you can opt to increase your coverage. Sometimes the optional additional coverage has medical underwriting, sometimes not. So I can't give you like a general statement about that. But if it doesn't require underwriting, your window period is a good chance to increase your disability insurance coverage. The one thing I need to warn you about, though, is switching jobs. If you change jobs, from one employer to the other, and the new employer has a group disability plan, most all of these plans, 99% of them, have a pre-existing condition limitation.
Mm-hmm.
By law, and once again, we're talking about California here, that's limited to 12 months. It can get a little fuzzy in terms of which state's law applies, but there's always going to be a period of time, let's say 12 months or 24 months, before that pre-existing condition limitation comes off.
Mm-hmm.
And so, you are at some risk if you change jobs after you get a PD diagnosis. If your condition takes a sudden decline, you might find yourself without disability coverage. So if you're thinking about switching jobs, do take a close look at the pre-existing condition provision in the new employer's disability coverage.
And can have a lawyer available.
Yes, that's even a better idea.
This is a good question from one of our members that came in by email in advance. That deals with a little bit of this, a little further up the chronological food chain. He says, what advice would you offer to someone preparing to inform their employer that they have PD because they need some reasonable accommodations to continue working? So other than what we've amplified over and over again about making sure you've got a good attorney nearby to answer these kinds of questions, what would you advise specifically?
Right. Well, I think I would, obviously in California, both under California law and federal law, there is a legal obligation on the part of the employer to provide a reasonable accommodation. And it's also illegal to discriminate against somebody on the basis of a medical condition or disability. And so what I would encourage you to do is have a very well thought out plan about what kinds of accommodations you need. This is something that you should present. You should have something in writing, to make sure that the request is clear. And I would encourage you to consult with a lawyer who advises people on, disability rights in the workplace to review the proposed accommodations with you, because certain things have been well accepted as being reasonable accommodations. Oftentimes, like switching for most people, like switching to a more limited schedule, or some other kinds of accommodations that might help people. There's kind of like wide support for some things. Might be more of a gray area.
Mm-hmm. I can speak to my own experience and say that my accommodations were to have one day off per week. So in the middle of the week, I was able to take Wednesday off. Of course, the workload stayed at a 5-day load, so that didn't help a lot. But and the other was, since my handwriting was going south and my typing was getting harder and harder, they purchased voice to type software for my laptop, so I could start using that. So those are some examples of types of accommodations. There are lots of others out there.
Right. Dragon software. Some people, need some adaptive devices like different kinds of keyboards, bigger computer monitors, things like that are common accommodations. But I think for people with PD, the most common one is to help you get some rest, and usually that requires getting additional time off or a shorter work week.
Yeah. Hey, Monique, I think we're gonna save a couple more questions that have just come in for the end, so we can get Travis to get his presentation in and a few questions for him. So I see those in the chat window. We'll bookmark those for at the end of the session. But thank you, Dan, very much. We'll be back to you in a minute. But
thank you.
Travis, would you like to share a screen, Travis?
Yes, I would.
Yeah,
Thank you.
I just unshared, so go for it.
Okay. Let's go. Here we go. Okay, hi. I'm Travis Neal, and you know what? I've set this up so I can't actually see any of you. Let me. All right. Great. There we go. Okay. All right. So, as Todd's mentioned, the slide deck will be available for all of you. So I'm going to go somewhat fast. I may skip some slides, but please feel free to review the slides after the presentation and reach out to me if you have any questions. The first slide I'm going to show is the general disclaimer. This is not legal advice. I'm going to apply this to Dan as well. I didn't see this in his slide deck, so I'm just gonna protect him as well with this disclaimer. It should also be noted that today is International Be Nice to Lawyers Day. So, just keep that in mind if you have any questions or comments for us.
Keep them nice.
Yeah, exactly. Okay. All right. So I get this a lot. Basically, I'm not wealthy, so do I really need an estate plan? Especially nowadays, I think many of us have heard, I can pass on, in 2022, for example, an individual can pass on $12 million to their heirs without paying any estate tax. And like, wow, okay, I mean, $12 million, that's a good amount of money. So do I really need to go through the process of getting a trust, a will, powers of attorney? And the answer is yes, because while you may not be subject to estate tax, that's not the only tax out there. And also, an estate plan is more than just avoiding taxes and making sure who you want to inherit will in fact inherit. Your estate is everything that you own at death. This includes digital assets like Bitcoins and NFTs these days. And more than just those assets, an estate plan allows you to specify who you want to speak for you when you are not able to. So who you want to speak for you in regards to financial planning, in regards to making gifts to family members, in regards to medical and personal care decisions, in regards to who would take over if you have minor children and you pass away, who's going to take care of those minor children. And also, I should say, you can also specify how your children or nieces or nephews or whomever, how they inherit. Do they get your money outright? Is it held in trust? So these are all the sort of considerations that go into making an estate plan or into an estate plan. And by doing that sooner rather than later, you and not someone else or the courts control how your life is governed now while you're alive, and then when you pass away. So yes, so unless you do all this now, you don't have to do it all now. But the important thing I would want you to take away is that you have control now to decide who you want to speak for you when you may not have the ability to speak for yourself any longer. So and whether that's because of incapacity or because of death. Yeah, just keep that in mind. And once you do have an estate plan in place, please be sure to review it. The sort of rule of thumb is every 5 years. But also if there's a change in your life, a marriage, a divorce, a death of a spouse or partner, a birth, those are all reasons to take a look at your existing estate plan. Okay, so now let's, I wanted to just briefly go over the main documents in an estate plan. So the one that sort of everyone has heard of is a will. A will is where you sort of say who will sort of gather all your assets when you pass away. That person is the executor, and then who will inherit your property. Those are the beneficiaries. In California, a will, if all you have is a will, your executor will have to go to probate court. So they will have to go to court, and the judge will sort of oversee the process of marshaling your assets and transferring them out. People are scared of probate court. I think it gets a bit of a bad rap. The judges I've worked with are all pretty decent. The process has slowed down during COVID, but it's not as bad as some people say. And then a trust, that's typically what we're talking about when we're talking about trusts, is a revocable living trust, meaning that you can change the words in it during your lifetime. And so that holds your assets during your life and then distributes them at your death. This allows you to avoid probate. It also allows someone, the trustee, to sort of take over management of the trust assets if you aren't able to do so because of incapacity or just wanting to sort of not have that responsibility anymore. And yeah, you avoid probate. You avoid probate fees, but your trustee can still take a fee. So there might be some cost savings with the trust, but that's not its main selling point, I would say. Yeah, so both wills and trusts do have the dispositive provisions, meaning sort of who will take over, or sort of who will inherit your property. Along with wills and trusts, it's good to keep in mind that there are other assets that may pass to a beneficiary outside of a will or a trust. So if you have bank or investment accounts that have pay on death, POD, or transfer on death, TOD, beneficiaries, then those assets will pass to someone outside of a will or trust. Retirement accounts have beneficiary designations. So it's good to keep that in mind. It's good to check on those beneficiary designations regularly to make sure they're in line with what you want. There's also commonly in California, people hold bank accounts or sometimes property in joint tenancy. It's good to keep in mind that in joint tenancy, the surviving joint tenant inherits the property by operation of law the second you pass away. So just sort of like that, there's not much to be done. So you want to make sure that you in fact want your joint tenant to inherit that property when you pass away. Okay. Any estate plan along with a will and a trust will have powers of attorney. And there's a financial power of attorney, and then there's what's sometimes known as a power of attorney for healthcare or an advanced healthcare directive. So just briefly, the financial power of attorney allows someone to, known as an attorney in fact or agent, to act on your behalf in your financial life. So this is often when it comes to, for example, retirement accounts, which we just talked about. If you need to change the beneficiary designations or you need to take withdrawals from a retirement account, your attorney in fact can do that on your behalf. A financial power of attorney can become effective immediately, meaning the agent can act on your behalf as soon as you sign it, or under certain conditions, whether that's when you become incapacitated or when you leave the country. That's known as a springing power of attorney. I generally recommend immediately effective powers of attorney, but I can get into that later if anyone has any questions. Advanced healthcare directives. These are often sort of not overlooked in an estate plan, but sort of like, oh, you sort of pass it over quickly. Someone fills out a questionnaire, and there's not a sort of meaningful discussion. But this is sort of where you really can have your voice heard when it comes to medical and personal care decisions. So it's not just about sort of what happens if you're unable to make medical decisions on your own. It's also, where do you want to live if you are, if you need some assistance, you need in-home care. Will that care be provided in home, or will that be at a skilled facility? You can specify, you can sort of instruct your agent here's what I want, as long as it's financially possible. You can request, spiritual or spiritual involvement. You can request being taken out for walks. So these are meaningful decisions that will enrich your life. And so it's important to have a meaningful conversation with whomever is doing your estate plan, and then also the person who will act as your agent under the Advanced Healthcare Directive. Okay, so now let's get into the 10 steps. So I've sort of laid the groundwork of what's involved, but I just wanted to sort of go through some steps that you can take. Hopefully this will make it easier, because I know people don't like to talk about death and sort of end of life care, but it's important. It will happen to all of us. And by sort of putting your plan in place now, you control what's in your plan. You control who will speak for you. You control who will inherit your estate when you pass away. So first of all, you need to get all your information together. So that is financial information, passwords and security codes. Don't send your passwords and security codes out by email, but do write them down, because that will be really helpful for someone like an executor, like a trustee, if they have to act on your behalf. If you already have some existing estate planning documents, make sure you gather those up. Get the contact information for beneficiaries, for the fiduciaries like the trustees or the attorneys. In fact, you'll want to provide that contact information to the attorney. Okay, then you need to sort of make the decision. Okay, who's going to speak on my behalf? Who's going to act on my behalf when I am unable to? One thing to keep in mind that people sort of get tripped up on is they have someone they trust, but they don't think that person has any real financial or investment acumen. So they're like, I don't know if I want, my brother Bob, he's a decent guy. I trust him. I know he would take care of my kids, but he's not always going to make the wisest investment. The thing to keep in mind is that a trustee or an attorney, in fact, can hire agents to help them out. So they can hire an investment advisor or financial advisor, just like you or I might. And so if brother Bob is smart enough to hire the right people, then he in fact might be a good choice if he would otherwise be good at making sure that the kids are taken care of, or you're taken care of. You can sort of tailor the amount of power a trustee or a agent under a durable power of attorney has. I think it's more important to find someone you trust than it is to, if you feel like you need to limit their powers, it's likely that you have perhaps chosen the wrong person and need to sort of think a little bit more about who you can trust, because we can't predict the future, and so you actually want to give your agents as much flexibility and discretion as possible. Okay, then again, the healthcare, I mean, it's a different type. The health and personal care, that's a different type of decision and interaction than the financial ones. So often people have, their trustee and their executor are different than who they nominate to be their agent under the Advanced Healthcare Directive. So, who do you have a good enough relationship with that you can talk about end of life decisions, personal care decisions, and who do you trust to sort of execute the plan that you want when it comes time? in the advanced healthcare directive, you can put both sort of end of life and afterlife considerations. So burial requests, organ donations, last rites, all of that can be done in the advanced healthcare directive. And also it includes a HIPAA release, so you will be giving someone the authority to access your medical records and speak to physicians. Okay, if you have minor children, you need to make a number of important decisions. First, you need to figure out sort of how you want to define children. Is that going to be only the children you have right now, or could that include future children, adopted children, out of wedlock? Some of this is maybe a little bit dated, but there is flexibility. If you have children or beneficiaries who will have special needs, you need to discuss that with an attorney so that when they receive their inheritance, it's in a special needs trust, so that they're properly taken care of, and any benefits they might be receiving from the government are protected. Obviously, when planning for children, the big thing is also choosing guardians. And a lot of my conversation with clients who are parents of young children involves making the guardianship decision and the factors that go into that. Okay, so you've sort of assembled all your documents. You've made some of the big decisions about sort of the trustee, who will speak on your behalf. So then you can create, you've decided you're going to create a living trust to hold your assets. Unfortunately, once you've signed the document, the trust document, you're only sort of halfway there. You actually have to fund the trust as well, because if you don't put any assets like bank accounts, investment accounts, your home into the trust, it's just an empty vessel that serves no purpose. So your attorney should work with you on sort of how to transfer assets into the trust during your lifetime. And then, if you open up a new account, or you sell your current home and move into buy another one, you need to be sure that it continues to be held in the name of the trust, so that it's considered a trust asset. And as long as you've done that, then should you not be able to manage the trust assets anymore on your own, whoever you've named as a successor trustee can step in and start managing those assets for you. And then when you pass away, that same person can help distribute the assets to your beneficiaries. And this is sort of a note of caution: trust not the only document to consider. So people get sort of singularly focused on the trust, maybe because their lawyer has told them to, and I've definitely been guilty of that. But you can't forget, I think I'm going to focus here on beneficiary designations. So a lot of people have a lot of wealth in their retirement accounts, and you want to make sure that your retirement accounts are aligned with the plan that you've created under your trust. So just by way of example, let's say if you pass away before your kids are age 30, then the trust assets are held in trust for the kids' benefit, and they can the trustee can pay for tuition or for room and board, but the kid doesn't get $1 million when they're 25. Well, if your retirement account, if your IRA has the kids named in their individual names, then whatever amounts are in your retirement account, the kids will have access to as long as they're over 18. Whereas a properly sort of considered beneficiary designation can make it so that it actually, that retirement account goes into trust if the kids are under 30, under a certain age. So you can sort of ensure that you have a sort of integrated parallel tracked plan. Okay, don't forget the will. Just this real quick. So even if you have a trust, you need a will, and the will is basically what I call a backstop. So if there's assets that should be in the trust but are not, the will can pour those assets into the trust, and then those assets will be distributed according to the terms of the trust. Also, if you have minor children, we put the guardianship provisions in the trust, sorry, in the will. Be sure your insurance coverage is in order. Obviously, Dan has covered the fourth bullet point quite well already, but there's, again, just because you have an estate plan doesn't mean you don't need sort of other sort of long-term considerations like liability insurance, life insurance, your homeowners. So insurance coverage, while you won't be getting it through your attorney, it should be considered part of your sort of it's considered under an expansive definition of estate plan. Okay, yeah, so step 8, the beneficiary designations. Okay, you know what, I'm running out of time, so I think I've talked about this enough. All right, because I did want to focus on the last two. So again, once you've done your estate plan, you've signed all the documents, let's say you've funded the trust, the work doesn't stop there. You do need to sort of talk to your trustees, the other fiduciaries that you've nominated, to make sure that they understand what you want, whether that's what you want under your advanced healthcare directive for medical decisions, or how you want certain assets managed. Have a conversation with them. Also prepare your beneficiaries. So if for whatever reason you are going to give more to one beneficiary than the other, it's better to talk about that now rather than after you pass away, because it's not gonna get better. It's not as if the ill feeling that could potentially be there is going to go away. Better to get it out in the open. And then last but not least, review, revisit, and revise. So yeah, again, tax laws can change, family situation can change, your assets can change, basically just who you want to benefit can change. So do look back at your estate planning documents, either when those life changes happen, or every 5 years or so. And with that, I see I've lost. I started out, there were 38 participants. Now there's 30. So I'm sorry, Todd. I did what I could. But,
Travis, I think you did great. And you're right that talking about death is not like talking about chocolate and strawberries and bunnies. So nobody likes to do that. But this kind of planning is really critical. And frankly, I didn't even think estate planning was a very fun topic until I started doing my folks not so long ago, and realized the importance of doing it for my own family. So you did great. Thank you for squeezing that all in. I'm sorry to our listeners and to you both to make it so abbreviated, but you both nailed it. Let me start the questioning then, Travis, for your category of, tell us what you think 2 or 3 of the real gotchas that someone needs to look out for if they haven't really dived in, or if they're starting to dive into estate planning. One of them might be the procrastination slide that you put up so subtly that says, should I start now, or can I wait?
No, you should start now. Definitely. I recently worked with clients where the husband had I would say waited too long, and then he came down with COVID, and that ultimately, after almost 2 months in the hospital, led to his passing. and he did not have his affairs in order. And so we are now dealing with the ramifications of that. We were able to get some things sort of in place in an emergency format, but frankly, by not planning, one of the issues is that one of the beneficiaries is probably going to have a viable claim to challenge how the father wanted to see the assets distributed,
Because it was rushed together so expeditiously.
Yeah.
So really good ducks in a row early.
Yeah, get your ducks in a row early. I think the other thing to keep in mind, this is fairly common question I get is, someone has let's say 2 kids, and they're like, okay, well, I want to nominate both of them to be co-trustees of the trust, so that because I want them to work together.
Mhm.
Being a trustee is not an honor. It's a lot of work, and so you are not favoring one kid over the other by making that kid the trustee. So that's why I say talk to your who you might nominate as trustees about it, but don't don't think you're shortchanging someone just because you're gonna leave them off.
Yeah,
Well, to follow up with that, Travis, are there any downsides to having co-trustees, or is it better to have one trustee?
As a there's no sort of general rule. I mean, it has to be sort of family, community specific. But we, and by we I mean the sort of attorneys in my firm, discourage co-trustees. It is an administrative difficulty to have 2 people, because banks, even if the trust says, hey, once the bank account's set up, either trustee can sign, the banks are going to say, okay, that's great, I want both trustees to sign every check, and then you're stuck. So I generally think find one trustee who you really trust, and go with them, and then you want some backups as well, but yeah, I would generally defer to sole trustees.
Great, thank you. It looks like Gary, you have your hand up. Would you like to ask your question directly to Travis, or would you like me to read it for you?
You can read it.
Okay.
Okay.
Can I move an annuity into a trust without it changing the terms, is the question.
I would need to see the document. That could be difficult. So I don't think so.
Good question.
Yeah, it was a good question. I think the answer is no, but I would want to do a little bit more research before answering that with 100% certainty.
Thank you.
Fair enough. We've got an observation more than a question here by one of our members, pointing out how California now has a TOD, and you'll have to remind us what that stands for. A TOD option for personal real estate holdings, but it does have some limitations.
Yes, so that's so there's now what's known as a revocable transfer on death deed, or a revocable TOD deed. I happen to be on sort of or be a part of the group of lawyers that helped get that law initially passed. Since then, they've added a bunch of additional hoops in the name of consumer protection. So I think it's still could still be useful, but frankly, it's now become a little bit more cumbersome. So it was supposed to simplify things for us regular folk, and frankly, it maybe has made it just as complicated in the end because attorneys got too involved. I apologize. So designating beneficiaries is sufficient for an annuity. Yes, if the annuity allows there to be beneficiaries, that there will be a payment on death. Yes. Yeah, actually, I think that, that whoever, Pat, thank you, Pat, for that question. Because there are a whole host of assets where they sort of come with beneficiary designations. And so you don't necessarily, you often can't transfer those into a trust, but you should keep those in mind when you're doing planning through a trust to make sure it's a well integrated plan.
Good tip. Hey, Travis, I'll lob you one that one of our members emailed me prior to the event that I shared with you in before we went live, but it resides more on the financial side of life planning than on the legal and estate side. But she asks, how does a reverse mortgage work? Specifically, what are the qualifications for a reverse mortgage? How do you find a trusted lender for a reverse mortgage? So you mentioned, I only bring this up because we talked about it in advance, and that your team has a chapter on reverse mortgages that you thought you could share with them. There you go.
Yeah, so I just shared it. And so just to be clear, so before joining Hartog Baer, Zabronsky and Barrier, I worked for a legal publisher. The UCs have a legal publisher, so I worked for it for 5 years. And one of the chapters in our elder law resources book was reverse mortgages. So I was able to print. It's not the cleanest print job, but I think it's legible, and it's actually a pretty readable chapter on the pitfalls of reverse mortgages, but also some of the benefits and sort of things to keep in mind if you believe a reverse mortgage might make sense for you.
That's great. I see it now. I'm going to save it and I will email it back to the member that asked the question. Thank you very much for that.
Aha, Medi-Cal payback.
Yeah, good for you. Keep going.
Of a trust. Yes, Colin, excellent question. Okay, so yes, so I feel sufficiently intelligent to talk about avoiding payback, but I'm not going to speak about eligibility. So I mean, there are requirements to be eligible for Medi-Cal. Resource requirements, and we could talk about more of that offline if someone wanted to email me about that. But when it comes to Medi-Cal payback, there was a law passed in I think the last 6 or 7 years, whereby any asset in a revocable trust would not be subject to a payback claim by the Department of Healthcare Services. So yes, all you have to do is transfer assets into a revocable trust, and then DHCS cannot seek repayment for Medi-Cal expenses paid on your behalf during your lifetime.
Great. Well, we've still got 5 minutes left. So Travis, if your feelings won't be hurt, and Dan hasn't nodded off, we'll lob him another question or two here.
Well, wait, Todd, we have Anne has her hand up. Why don't we give her a chance to ask Travis a question if she has?
Good catch.
And
Actually, I had a question for Dan,
Sure.
if that's okay. So I was interested in a couple of things in your remarks, which were really comprehensive. So thank you for that. One of I guess it was Todd who mentioned that, and you also, that a common accommodation is a limited schedule. I guess it's a two-part question. One is, well, what is the difference between an accommodation in which reduces your work schedule and partial disability? And the second question is a little more personal. Prior to my diagnosis and prior to COVID, I was working 12-hour days and traveling 100,000 miles a year, flying. And so, I mean, I'm kind of curious, what if your job is mandated as to conventional 40 hours a week, but to do it, it's a 60-hour-a-week job? How does that factor into disability at the time when you sort of say, I can't do that anymore?
Right. Well, your question is kind of mixing two things together. First of all, what is a reasonable accommodation will vary, from job to job. I mean, like, just to give a very clear-cut example, if you're a firefighter, saying, oh, I can no longer like lift heavy things, so give me an accommodation so I don't have to like do that. That doesn't work for a firefighter. You could switch to a desk job, and that might be the reasonable accommodation there. But there's no clear-cut answer about what's a reasonable accommodation, because it can be quite specific to a job. Now, the tricky thing for people with a chronic illness like PD that is progressive is picking the time when you say, I can no longer work the way I've been working. I either need to file for disability or file for partial disability. And that you came up with you used the phrase partial disability. And that's something I didn't touch on because it was an abbreviated session, but some, but not all disability policies will provide for a partial disability benefit. Sometimes it's referred to as a residual disability benefit. That's a confusing term, but let's use partial disability. And for most policies that have this benefit, and once again, it's not all of them, you'll find that if you are prevented from doing some, but not all of the material duties of your job and continue to work, but are now, you now have a loss of income, and the loss of income has to be 20% or more of your pre-disability earnings. Typically, you can get a partial disability benefit, which is usually just simply pro rata. If you've had a 25% loss of your pre-disability earnings, then you get 25%, essentially of the LTD benefit. Let's not go into the math because the formulas can vary. So, when you're looking at the definition of disability and your policy terms, certainly for many folks who have sort of a let's say a long, slow decline because of increasing symptoms, you want to see if you have a partial disability benefit, and that may often be a good option, or at least an initial option. But a partial disability and reasonable accommodation are are like under different regimes. One is your right to continue to hold your job, and the other is your right to get benefits because you can't do the job the way you used to. And they certainly are related that way, but one question kind of goes to your employer and the other question goes to the insurer. Did that help?
Yep. Yeah, it does. Thank you.
And certainly something that people like me are starting to deal with in a new way that I never thought I'd see before is, what are the material duties of a job? Because I too have clients who used to travel, 100,000 a year. My hat's off to you. That's crazy. But I have a client now who I'm advising who had to like fly back and forth between LA and San Francisco a couple times a week, pretty much every week. And I don't think he got to 100,000 miles, but that's a lot of miles. And well, actually, maybe he did. But, like since everybody's on Zoom now and people aren't traveling as much, like what are the material duties of a job? And some policies say we won't consider hours beyond 40 hours a week to be a material duty. Sometimes they're written like that. But, for now, I've been taking the position that changes to work duties due to the pandemic are temporary. And I've been telling insurance companies, hey, you got to pay my client benefits because he or she can't, meet that travel schedule anymore. And I haven't actually been getting pushback from the carriers on that yet. sure it will come eventually, but I haven't run into that one yet.
Interesting, thank you.
Great. Well, we have hit the top of the hour, a little bit beyond, but we've still got 28 folks listening in. So if it's okay with everybody, we might just field a few more questions and then wrap in 2 or 3 minutes. I hope that's all right. Because we do have a couple more here. I'm gonna grab this one, Monique, and then you can grab the one from Gabriel. What are the disability? This is Dan. What are the disability options after 24 months of SSD if the person covered does not have LTD, long-term disability insurance?
Yeah, so some of these that have been coming up while Travis was talking, I've been responding to, not to the group, but a direct message to the person who asked it. And that question, that's one of the ones, I think I've responded to all of them that were posted to me. So that one is also, I think, a little bit confusing because Social Security, if SSD is Social Security disability insurance benefits, it doesn't end after 24 months. It goes until age 65 or
You might have meant STD, short-term disability.
yeah, no, or state disability insurance. So those end after 52 weeks if it's Cal State disability insurance. Short-term disability STD, those policies vary. Sometimes it's 1 year, sometimes it's 180 days.
Mhm.
So I guess if you only have short-term disability benefits that end, then you would have to, and you don't have long-term disability insurance, then you would have to be looking at Social Security disability insurance. That would be your only option. But the question is phrased a little strangely, because 24 months would be an unusual period for a short-term disability program. I mean, it may exist, but I haven't run into that one before.
Yeah,
It's usually 12 months or less.
Yeah, mine was 12. Okay, Monique.
I think the other question, I'm not sure if you already responded to, that was asked directly to you about if you're self-employed and have an individual policy, is there a governmental disability program in addition to your private policy?
Yeah, I responded to that one as well. So if you're self-employed, you're paying into Social Security. I mean, I count as self-employed and I have to pay Social Security taxes every year, just like anybody else. And if you're paying into the Social Security program, you are eligible to get Social Security disability insurance benefits. And people who have individual disability coverage, get more out of Social Security disability insurance benefits if they qualify than other folks, because your individual policy doesn't have any offsets. So your SSDI benefits are going to go into your pocket, not to the insurer. And most people who have a disability are worried about medical coverage, and qualifying for Medicare after being out of work for 24 months is helpful.
And if you are getting Social Security disability, does it affect your later Social Security benefits?
So yeah, it's basically
Calculated on.
they're going to be frozen at the level when you went out on SSDI. You're not paying into the system anymore. You're taking money out of it, and so while you're working, you're accruing additional benefits. Your benefits going up a little bit each year as you pay in, and that's just not going to happen once you essentially start taking money out rather than putting money in. Somebody asked a squirrely question, one I had not run into before, about, well, if I get SSDI, can I stop at age 65 and then take my Social Security retirement benefit at a later age, like 70 or something? Because as you all know, if you take your Social Security retirement benefit later, the monthly amount goes up.
Mhm.
If you take it at age 68, let's say, or 69, the monthly amount's higher than if you take it at 65. And, I actually don't know the answer to that because all my clients who have been on SSDI at age 65 just keep on going. I've never had somebody try to stop out and see if that one works. So that's one of those questions I never would have thought of before.
Mhm. Hey, I have my own word of caution, Dan, based on my experience and a gotcha that I've stumbled upon, and that is that long-term disability benefits paid from a group carrier are taxable.
Mm.
That once again, everything requires master. And so what you said is not quite accurate. What's important is who pays the premiums. So if you buy individual disability coverage, obviously you're paying the premiums,
Right.
and that means the benefits you get from the individual policy are not taxable income to you.
Correct.
For group disability benefits, I would say the majority of the time, the employer pays the premium. If the employer pays the premium, then the disability benefits are taxable income to you. But there are nevertheless group plans where the employees either pay the premiums as a payroll deduction, in which case they're the ones paying the premiums and the benefits are not taxable, or they have the option to do so. And once again, I'm, as Travis said, I'm not giving legal advice here. This is a group presentation and it's not a one-on-one consult with a lawyer. But nevertheless, I will say that, somebody who has the option to switch from having the employer pay the premium to paying the premium out of your own pocket, if you've been diagnosed recently with a condition like Parkinson's disease, where it's likely to get worse, you'll have a window period typically where you can switch and start paying the premiums as a payroll deduction. That would be a smart move in that kind of scenario, because if and when you do go out on disability, it makes a big difference to have a tax-free benefit.
I'm glad to be corrected on that because people should know that. I mean, for me, I was getting my private individual benefits paid and not being required to pay tax. So I thought the same would apply to the group benefits, but lo and behold, I got a big tax bill I had to pay in reverse. So let's wrap. Thank you, gentlemen, very, very much. We're at almost 10 minutes after the hour, so we should draw this to a close. Let's just say that there are two strong bits of advice on the disability side of things. Find that lawyer, find them early, get advice early. On the estate planning side of things, the same things. Do it early, don't wait, and cover off on those bases before it's too late. Guys, thanks a ton for your time today. Everyone, thanks for joining us. It's been a pleasure. One last reminder, on the 14th of May, Saturday, from 1 to 3 p.m. is our mini info fair up at Lake Temescal. We would love to see some of you there. And otherwise, we hope you have a nice evening and a good rest of your week. Take care, everybody. Good night.
Good night. Thank you.
Thank you again, Dan and Travis.
Yeah.
Yep.